I don't even know how that came out of your mouth.
I'm sorry.
I'm purpose recess.
All right. Please don't hold that against my client. That's me.
Well, I'm not holding, Mr.
Well, I mean, I understand.
holding it against anybody. I'm saying I'm not getting a satisfactory answer, but I am troubled by the responses that I'm getting to my question. The people of the state of Michigan versus Matthew Wheeler.
Good afternoon, Your Honor. Laura Billenberg, on behalf of the people.
Good afternoon, Judge. Larry Margolis on behalf of the defendant, Mr. Wheeler. Please state your name.
Good afternoon, Judge. My name is Matthew John Wheeler.
All right, this is your motion, Mr. Margolis.
Thank you, Judge. Where would you like me to stand, Your Honor?
Wherever you'd like, sir.
I don't know why I like the podium, but let's try that. Judge, we are seeking to have the bond reduced in this matter. It's set at $150,000 cash or surety. It's not something that Mr. Wheeler is able to make. He is a 44-year-old resident of Washtenaw County, has lived his whole life. I say that initially because in the bond, I have the arraignment where his lawyer at the time said he has no family in the area, and the magistrate said that he may be a flight risk. I wanted just to correct the record on that because his family, the entire family except for his brother, lives in the state of Michigan, lives in the directly in the Metro Detroit area. His father is in the courtroom today. His brother, who came in from Maryland, is in the courtroom today as well. Mr. Wheeler was taken into custody in this case on October 15th, and he's stayed in custody since that time. As I said, he has very, very strong ties to this community, and he is not a risk of flight whatsoever. He has no reported criminal history, Your Honor. He has a long and positive employment history. He's been employed as a martial arts instructor, and that's where the allegations arose from, but he's been employed there since 2010 when he was an instructor, and then he took ownership of the school in 2022. So for 15, give or take, years, he's been teaching at that location. This is the first allegation that arose. He's been working with kids throughout that time. He has a lot of positive support. I've attached some letters of reference for Your Honor, and I can go through those, but I obviously don't need to. I've been getting more emails to my office. What can I do to help this individual? I was walking into court this afternoon. Attorney Jonathan Sachs said, Larry, come here. He brings me over. He says, Mr. Wheeler has been coaching or teaching my son for years. Do you need me to stay around? And I said, yes, as long as you can. But then he had to go. He said, please use my name to the court. This man has standing in this community is what I'm trying to tell the court. He's very close to his family. He's a caring son and brother. He's highly disciplined and respectful of others. His mother would be here. He cares for his mother in large part. She is aging and not well. She wanted to be here, but she's at Chelsea Hospital right now. So she is sending her support from afar. As far as him being a danger to the community, Judge, he's not. Again, he's lived in this community his whole life. This is his first criminal charge lifetime. He's actively involved with his defense. He would do nothing to jeopardize it. And we're seeking to have Your Honor reduce this to either a 10% in a lower amount that the family can make. There are conditions that can be placed upon him. So we're asking Your Honor to modify that bond. Defer to the people at this time.
Response.
Your Honor, I wrote in my motion that I am asking that bond remain as set. I reviewed and charged this case and originally requested a $50,000 bond, and Magistrate Odetella, of his own volition, set the bond at $150,000 because he thought that was appropriate. The victim in this case, the assault and the grooming started when she was 12. She started training in martial arts when she was 6. Defendant was someone that she very much trusted and admired and looked up to, and the allegations are that he took advantage of that and of a child, began grooming her and assaulting her when she was 12. And then 3 days after the most recent incident, she reported it and told her mom what was happening, what had been happening. He touched her breasts, her thighs, her vagina, and this was when they were alone together, either in his vehicle or at the martial arts studio. Also made, several concerning statements to her, like that the age gap isn't that bad. I have concerns given that, yes, these are the first allegations, but his job is essentially direct access to children. I have concerns, obviously, given the report of this child, and I think that the bond is appropriately set at this time, especially given that the magistrate saw it, that it was even more serious than I requested, and increased it to $150,000 on his own. So I'm going to request that bond remain as it is set.
Briefly. Judge, Mr. Wheeler denies any of the sexual allegations that this young person is making. He has been working with children and adults for 15 years. He had been working with this individual for 8.5 years, and in her own statement, she says that there was some touching that happened, and then she continued to stay for the next 20 months. There's a lot of facts.
Yeah, but I don't know what you're asking me to make out of that, Mr. Margolis.
Only that there's one person who's alleging this, and that one person continued to stay at the dojo.
Yeah, but this isn't a circumstance. Well, it's a child that then she doesn't remove her. She's not in a position to remove herself, right?
Well, I mean, she rose up and became a coach, and she was very involved. That's all I'm saying.
No, what I'm saying is that you're making it sound as though this is an individual who this is going on, or is at least alleging that this is going on, and chose to stay. I mean, she's a child, so the reality is she's going to be there until such time as she has the fortitude to tell her parents, because they're the ones that are going to take her out, right? I mean, or are you saying something different?
No, I'm not gonna quabble, or is that the word? I don't think it's important to contest that point with the court. How's that?
Yeah, but I'm trying to figure out what your statement, how I'm supposed to take your statement that this is occurring to her and that she stayed. What am I supposed to do with that notion that she stayed? Because when she stays, it's my presumption, unless you know something different, is that she stays because she can't or doesn't tell her parents, so then she's not taken out.
I didn't get that impression from my review of her statement and the discovery, Judge. I got the impression that she stayed because she said it was her whole life. The dojo and the dojo community was her whole life, I think, is what I recall the statement being that I reviewed this afternoon.
Okay.
The point is, that I'm trying to make is that there's a PPO in place. Once she stopped going, there was no problems with Mr. Wheeler, trying to get her to come back or going to the house or anything like that. He's a respectful person. He's a good person, Judge. And he denies this. And so all I'm asking is for his presumption of innocence to be, upheld, allow him to get the benefit of the doubt without, there's no evidence other than her statement, which is common in these cases, as Your Honor well knows. Again, he's been in this community, contributing to this community. That's why I attached, for Your Honor, all the reports, the Quest references. Quest has changed my life. An amazing experience. Our kids love spending time at Quest. So we have a community of children that have had great experiences. And yes, we've had this one that is now making these allegations, but it's probable cause. He's never been in trouble in his life. He's college educated. His family's here in support. He has a close family. I'm just asking for him to be given a reasonable bond such that we can work together on the outside.
What would he, presuming he were released, is he going to continue to operate this business or what?
So he doesn't have to, if the court were to release him, there are conditions. He should not, if there are court such as like, okay, let's not allow him to be around kids unsupervised. That's an easy one. There's been no,
Well, but that's not an easy one because,
as a condition.
as I read, because I pulled the swear to and the other thing, and then as I'm reading this, there's an indication that somehow or another he's up this child. Why is that occurring? I get.
No, it's a great question.
Teacher.
Yep. So the family only had one car. He was close with mom and the family too. So the family would rely on him for transportation for a long period of time. This was a family that had been at the dojo. And these are small, tight-knit communities. And so this was a family that was at the dojo for 8.5 years. And so they had one car. And so mom would request that he assist in the transportation. And he would. That's why, to answer the court's question.
So the other part of that, though, is that, so if I were to release him or he were released, he would go back into the same environment to work?
Not necessarily. I think the lease has now been gone. He has other abilities. He also has another job doing something else. I forget exactly what it was. What was the other job? Yeah, he also was working at a warehouse doing shipping and receiving to make extra money. Yes, that was his business, and he eventually in his life.
Okay, I'm not getting a straight answer. If he were released, would he go back to operating this business?
No.